Hello, and welcome to our periodic webcasts at the Syracuse Intellectual Property Law Institute and Technology Law Commercialization Program at Syracuse University College of Law. This is Professor Shubha Ghosh, and it's with great pleasure that I introduce Judith Finell, musicologist, professor at UCLA Law School. Ms. Finell is a musicologist and has served as an expert witness and consultant in many music copyright disputes throughout the US and abroad. She joined the UCLA faculty in 2019 and teaches the only course on forensic musicology in the country. She also advises film, television, advertising, media, and tech companies on a wide variety of music topics, including digital sampling, music rights, infringement, and public domain. In addition to testifying in many notable copyright trials over the past 2 decades, she was the testifying expert for the Marvin Gaye estate against Pharrell Williams in the Blurred Lines trial in federal district court, and also before the Copyright Royalty Board on behalf of the National Music Publishing Association regarding ringtones. She presides over Judith Finell Music Services, a music consulting firm in Los Angeles and New York, with a team of musicologists advising attorneys and their clients on music copyright issues. Assisting her today, and I think you may see his name over the black backdrop, Justin Rosen, who will be assisting with the slides. But welcome, Judith. Thank you for joining us today, and welcome, Justin, as well.
Thank you very much for inviting me, and I look forward to sharing some of these ideas with your audience. So thank you. I just wanted to make one
quick, I'm sorry to interrupt. One quick, Justin, are you sharing the screen? Can we?
Yep, I am.
Okay. Sorry to interrupt, Judith.
No, that's fine. My course is offered in the law school, but it's under the umbrella of the UCLA music department. I don't know if I'm not employed by the law school. I'm employed by the music department.
Okay,
Okay,
thanks for the clarification.
But thank you. So next slide, please. So I wanted to start by explaining to you a little bit about sort of the intersection in which my work is found. Meaning my background is in music theory, analysis, music history, and many other areas of musical knowledge, including I began as a musician, as a pianist, and then grew into my interest in musicology, which is the study of music in various forms. Many musicologists are in academic institutions and they focus on one particular style or say one composer. They may do all of their work focusing on Beethoven, for example, or one particular region of the world where they may study the music of a specific nation or a specific folk culture. So there's a wide diversity of ways in which musicologists study the area. And I am what you would call a generalist in that I have a deep academic background in music theory, analysis, comparison, and literature. And thus, I've been called on as an expert and a consultant in disputes involving the protection of music as intellectual property. But my background is as a musicologist, not as an attorney. Most of the people I work with are either attorneys themselves or have sometimes been sent by attorneys considering some of the legal risks or considerations they are facing. And that's why technology is a big element. Because as any of you know who listen to music or write music, technology has changed the way music is created, the way it's shared, the way it's distributed, the way it's heard, and the way it's experienced greatly in your lifetimes, most likely. But this goes back quite far in music history and in world history. And technology can create both challenges and supports for the legal protection of music creativity. Next slide. So there has been a long history of music connected with machines or technology in its general sense. In other words, since the creation of the printing press, which was really invented so that Bibles could be reproduced and distributed, but that enabled music to be copied and multiplied and distributed, so that when you think, and this is hundreds of years ago, so when you think of the way music was first written down, because that's how music was taught and performed originally, this is way before recordings existed. Recordings were a relatively recent invention. So first, the only way someone could learn a piece of music was for the composer to give that person what you would call a score, which is the written notation of the music composed. And often these scores existed in only a single copy because it was handwritten by the composer, or what is called a copyist, whose profession it is to write down music like that. Or if it were religious music, then monks and all were actually trained in music notation and what was called calligraphy. And this is how music existed in a single version when it could not yet be duplicated. So the printing press completely revolutionized any document that needed to be reproduced, including a piece of music. But as soon as it could be duplicated, this also challenges the protection of the music from being copied or shown to unauthorized people, etc. And that's sort of the rollout of copyright protection and the challenges produced by the machine-enabled technologies. This hasn't stopped until today. It still hasn't stopped, but when you think about some of the later inventions that we've all experienced, again, music could be originally, music could be experienced on a one-time basis inside the setting where the music was being performed, whether it was a church or a concert hall or what's called a chamber within, say, usually an affluent person's home, a music room, say, and for small settings, etc. But you couldn't record it. You couldn't write it down, or you couldn't reproduce it or perform it if you couldn't in some way memorize it, for example. So when the ability to duplicate music in both an audio form in terms of creating recordings and broadcast it in radio and television came into being, this completely changed again the history and the development of music, because it became available to be heard. It was available to be stored so that you didn't have to go to this one-time performance or miss it entirely. And it could be shown throughout many territories. And of course, when digitization occurred and music moved from analog to digital format, even more abilities were created. And today, music is shared all over the world, while it has been written maybe in one particular vicinity, say in Iceland, but within moments of its being composed, if that composer wants to, he or she can post it on social media and other kinds of platforms and start sharing it online throughout the world. And why is this an issue? Because of many reasons. One is that once music was digitized, it meant that any other individual who had the right technology, which was very inexpensive, could capture a recording and use it in another recording, for example, or just take out, depending on the sophistication of that person's devices, could take out, say, just the guitar line and replicate it on another recording or another work without permission, or with permission. I mean, a whole business eventually established itself, but this took decades. Or they could listen to it at a different time from when it was actually performed, or they could record it and play it back in a different time and location, or under different circumstances, with or without the permission of the musicians. So this partnership has continued, and today we'll talk a little bit about the present day, in which music is now being composed with the help of artificial intelligence, which again is an extension of the original music protocol in which a composer wrote notes or composed and thought of notes, and as in pitches, rhythms, and instrumentation and harmony. And now that is often replicated by machines that are taught, in essence, to recognize musical patterns and all of the metrics of music, such as volume, speed, etc., pitch and rhythm, and replicate it in similarly patterned music that have actually been created by a non-human. And that's where we are. So it's been a long road. It's not over, and we'll continue from there. Next slide. So where does a musicologist come in? And this is where I am often asked to opine on whether or not two pieces of music sound alike. Sometimes it's sound and sometimes it's visual, by the way. But in any event, if two pieces of music, if there's a dispute that music B, meaning the later written music, replicates something from music A. And I'm often presented with two songs or two symphonic scores or two film scores or an advertisement that is based on a previous song, and asked for an opinion on these things. And it's really due to my training, in which I can diagnose the pitches, the rhythms, the harmonies, and all, which we'll get to a little bit later. But basically, I've been taught the musical criteria that I would apply with my training so that I can really look at it on a deep level. And that's what we're going to talk about in some of the cases today. Next slide. We'll move now to one of the well-known, very controversial cases in which I was an expert witness, meaning that I testified on the musical similarities and the differences between a song by Marvin Gaye called "Got to Give It Up" and a song that came out about 30 years later by, actually almost 40 years later, by Pharrell Williams and Robin Thicke, called "Blurred Lines." The real challenge in this case, unlike any case I've seen before or since, and I've been doing this kind of testimony work and consulting on music disputes for about 25 years now, I have never seen a case in which the recordings at issue were blocked from being heard by the judge and the jury, or being considered by the legal team. But in this case, that was done, and I'll leave that up to your professor and others to explain why. But in the end, even though my initial assignment 2 years before trial was to compare Marvin Gaye's recording to Robin Thicke's recording and determine if I found similarities or differences, and if so, what they were, and identifying them, as the trial approached, the opposing side was able to bar the recording itself from being heard. And I remember clearly every day, the judge would look at the jury and say, "Thank you for your service today. Please do not go home and listen to Marvin Gaye's song." And I do not know if that was honored or not, but the judge did not want the entirety of Marvin Gaye's recording to be heard in court for technical legal reasons in terms of what Marvin Gaye's estate owned. So we were left with what was called the lead sheet, which was a sheet of music. And that was meant to be compared to the recording of Pharrell Williams, which was not barred. So it was basically comparing a piece of paper that very few people, certainly in the jury or the judge, were not capable of reading, because that was one of the questions that they were asked in selecting the jury, if they were capable of reading music or not, and most were not. And then the other side's recording, which didn't have a lead sheet because of changes in the copyright law requirements by the United States Copyright Office in those intervening decades. Next slide. So as a musicologist, one of my challenges was, as an educator, to basically help the jury and the judge understand what the musical comparison was, what to focus on, and what was important in, at least in my opinion, of the musical similarities between these two works. So I wanted you to hear a little bit of each for reference, but please be aware that the jury actually didn't hear this full released version of Marvin Gaye's Got to Give It Up. We'll just hear it for a moment so you could start to see why there was an issue between these parties. So please play the first audio.
Everybody get up.
So, you know, those of you listening may think, oh, this is just a similar, what was often referred to in the subsequent press after the trial as a vibe, or it's just a stylistic relationship. But in fact, I was able to identify through the analysis of each work 8 similarities that existed quite widely between Blurred Lines and Got to Give It Up if only the sheet music were considered. But if the recordings were allowed in as they were initially, I found over 14 similarities that the two had similarities in exact compositional material. And by that, I mean protected elements, that this in its own way was a classic copyright infringement case, though within the press, including unfortunately some mistakes that legal scholars and music scholars made. They saw it as a similarity in style, but in fact it wasn't the style. Where the style was similar were in similar uses of instrumentation such as cowbells and some other commonplace features, but when I studied those, I saw the cowbells weren't playing the same notes. So I did not consider those one of the constellation of similarities that I found. Next slide. Here is the first page of the sheet music, which was called a lead sheet, which in the year that Marvin Gaye wrote his song was required to be submitted in order to have copyright protection. This is called the deposit copy is the term that's used. By the time Pharrell Williams' song was written, lead sheets were no longer required and one could submit a recording. And that became the deposit copy. And that's why the parties on the opposing side, that's why, and there was also some ownership of the elements that were protected by Marvin Gaye's family. Those were the ways in which it was barred, meaning this lead sheet was what we were allowed to use. And if it were reflected on the lead sheet, the judge eventually allowed us to present recordings that represented the individual features shown on the lead sheet. But for those of you who do read music, you'll see, you'll see staves, which means groups of 5 lines. The first stave is, represents the first few bars of the introduction of Marvin Gaye's song where the bass line is playing, and it continues on the second stave, the second group of 5 lines, and then it stops. So the first 8 bars of what you're looking at here is basically the bass line with nothing else showing except chord symbols. And then it says, it's very hard to read here because it's very light and very old manuscript, but it says bass simile, which basically means continue with the bass line as it's been here throughout the rest of the song. And then the vocal line comes in where some lyrics are showing. So we were restricted in terms of, we were allowed to show the bass line in an audio clip that was shown in the trial, and we are allowed to show the chords that were shown here, which were played by the keyboard during the trial. And this was continued throughout both songs till from the beginning to the end, and was very similar with Blurred Lines, that song. They weren't identical, but they were quite close. And we also found other similarities that were part of what I was calling this constellation. But Marvin Gaye did not read or write sheet music. So this was done by a third-party copyist whose job I believe was working for the music publisher who published Marvin Gaye's music. And this was that particular person's version of what the recording studio had done, what occurred, excuse me, during the recording process, and what that particular copyist was capable of writing down. And as you can, you may know from listening to what I played for you, that you had a lot of things going on at once, including drums, keyboards, other instruments, and eventually voice and backup singers and party sounds where you heard speaking and all. None of that's represented here. So the recording wasn't really represented on this piece of paper, but key elements of it were enough that there were 8 similarities found that went throughout Blurred Lines. And that's why I called it a constellation, because they came and went and musically influenced one another in a similar way in both songs. Next slide.
Judith, can I ask you just some clarifying questions?
Yes.
You talked about the lead sheet, but was it the entire score for Marvin Gaye that was deposited? And it's not just
yes, it was many pages long.
Yeah, many pages long. And I know there's some reference to like a fake book. Is that somehow relevant here as well? I mean, this would be would this be an exact translation of the musical performance that we're seeing here and in the score, or is it just you mentioned the copyist would? Could you elaborate on that a little bit?
Of course, thank you for asking. So just to distinguish, a fake book is something that a publisher puts out for musicians and sometimes amateurs to play, to sort of have notation of the basics of a song, which is usually the lyrics and a piano line with guitar chords, or, and that's about it. This is not a fake book. A fake book is something that a publisher uses to sell copies of the song and market it and maximize its distribution to the public. This is the piece of paper. That's why it's called a lead sheet. It's meant as a skeletal representation of a much more complex recording. But at the time that this was submitted in the 1980s, it was the only way in which you could gain copyright protection for what you call the composition, the C in the circle.
And so when you did your work, Judith, let me make sure I understand this. You were comparing this lead sheet with the actual musical, if you will, musical performance of the Pharrell Williams work, right? You weren't translating Pharrell Williams' work into its own lead sheet and doing a comparison.
Well, I should explain there were stages. This challenge of the recording of both did not emerge until about 1.5 years into the dispute, before the trial, and when there was a motion for summary judgment motion and all placed. So my initial analysis was recording to recording. The lead sheet, I didn't even have a copy of the lead sheet. So I was comparing the recording that you just heard the beginning of each song. And then later the recording was eliminated and I was given this lead sheet. So the comparison had to be reduced to only what was represented on the lead sheet, which is basically 1 item per line, when there may have been 10 things going on at a given moment in the music, and comparing that to the recording of Pharrell Williams, because there was no lead sheet by Pharrell Williams. There's sheet music on the market, but that's the equivalent of a fake book. That wasn't considered the official Pharrell Williams music. So we did notate what was on the recording by Pharrell Williams so that we can compare are notated versions of each to one another originally.
Right.
But when the recording was eliminated, then Marvin Gaye's recording had to be removed from the equation.
So for a non-musicologist, it sounds like it's almost apples and oranges type comparison. But I mean, is it sort of like, are you playing the lead sheet in your head, or are you translating the performance into a lead sheet? I mean, how do you envision that? I can see how it's happening, but for a non-expert, how would you describe that process? So
Okay, so for someone with my training, I can look at notes and know what they sound like without hearing any recording for reference. So that, I mean, that's just part of my training and my musical background. But my job was to make it understandable to a lay listener, meaning the jury, judge and jury. So yes, so the translation was basically, eventually, this is what I was allowed to do. I was allowed to have a piano, an electronic piano in the courtroom, and I illustrated by playing music that way. And the judge on the eve of trial did agree to our playing very small excerpts from Marvin Gaye's recording that edited out. We had to do this in a professional studio that edited out anything that the lead sheet didn't show. So for example, if there were tambourines playing or flute or backup singers and it wasn't on the lead sheet, we could not allow that to be heard in the courtroom. So we took from we were given basically the tracks from the Marvin Gaye original, and we had to strip away and then get it approved. There were documents going back and forth. It had to be approved by the judge as representative and in no way going beyond this piece of paper.
Judith, maybe you're going to get into this. Sorry if I'm preempting it, but if you were, when you're preparing your testimony, let's say you're comparing the two recordings, how do you do that type of comparison? Is that based upon you as an expert hearing the two recordings, or do you go deep into a technical analysis? I mean, do you do a breakdown of, what exactly would be the forensics if you were comparing the two recordings?
Right. So yes, I do a breakdown. I mean, usually say I'm comparing Got to Give It Up with Blurred Lines, for example, just the recordings, forgetting about this sheet music. Yes, I would listen to it. I mean, for many hours. I would study each song in great detail, determine what I believed was similar, if anything, between them. And then I would start to notate it. They're usually in different keys. It's unusual to find them both in the same key, but I would first notate it as it is on the recording, usually line by line, like the bass, the drums, the vocal line. I would create a score in essence, which is a piece of sheet music that represents the sounds, and then transpose them into the same key and look at them and study them and see if on very close examination, they share melody. Melody is pitch plus rhythm. So I'd be looking at both the pitches, meaning that what you might think of as notes like a C, a D, an E, and the rhythms, which means how long those notes are held, how many beats they're held, and if they're the same. And then I would look at chords. And as you see, there are capital letters for chords above each group of musical lines here. It says A7, for example, in the beginning, and later it says other chord names. That represents 3 pitches that are combined, or in this case, 4. An A7 chord consists of 4 specific notes that you would say strum on a guitar, you could play on a piano. And it turned out that the chords between the 2 songs were the same 2 alternating chords. And that was one of the constellation of similarities I was permitted to show because it's shown on the lead sheet.
No,
Does that answer?
No, this is wonderful. So for viewers, we had Professors Latif Fatima and Sean O'Connor on a previous webcast from 2 or 3 years ago, and we talked a lot about the lead sheet from a legal perspective in terms of what was required to get copyright protection back in the 1980s. So it's great to get now a fuller picture about how this was applied in court by the experts. So thank you.
Thank you. I just wanted to tell you that they may have said this because they're so knowledgeable. it turns out that if Marvin Gaye's song had been written only 1 year later, it would have been able to have the entirety of the recording represented.
That just to clarify, that just had to do with the technology of the Copyright Office in terms of how you recorded these things and deposited these things. I mean, recorded in the legal sense of recording, deposited with the office.
Well,
So,
okay, thank you. I didn't know that was the reason, but it completely revolutionized music industry, because suddenly everything on a recording, that you can see that this is just representing sort of one item at a time, when at any moment, any listener can tell there's a lot of things going on simultaneously, and this doesn't show that,
and
but
it's
a
really
recording
interesting.
does.
Yeah. And it's really
So-
interesting from the legal perspective on infringement, that talks often about an ordinary observer, or here the ordinary listener, what they would see in terms of substantial similarities, of course, aided by an expert. So the legal overlay in terms of legal standard, it's really interesting from that perspective. Do you think
Yeah, I'm sure.
do you think it would have made a difference from your expert opinion as to the outcome of the case?
It wouldn't have made, I think that the outcome was actually, it kind of backfired against the other people, in the sense that being limited as much as we were, it was actually an advantage to showing the jury what was similar only.
Yeah. Even though it sounded like you were saying when you compared the actual recordings, there were more similarities.
There were more similarities though. So I
Yeah.
don't know. I mean, since Marvin Gaye's case won, and it also won on 2 appeals, I don't know if it wouldn't have changed it anymore, but I would think it would have been more obvious what the similarities were.
Yeah, it's interesting. We had a good discussion too, and we're continuing that here with Professors Matima and Connor about the dynamics of this case in terms of how much of it was the legal standard and how much of it was the sympathies of the parties, and how the jury was swayed. It's really interesting, this case, just all the things that were going on, and
Yeah.
classic rock and roll versus, for lack of a better term, hip hop. I mean, it's a really interesting cross-generational
Oh, yeah. Yeah.
aspect too. Well, thank you. I didn't mean to interrupt you, but that was great.
No, thank you.
There's,
Interesting questions that need to be thought about, for sure. Thank you. So we'll move through this just due to time constraints. And next slide, please. So I wanted to point out a couple of kind of the more stunning similarities that were uncovered. And as I say, the literature has created a certain amount of myths and misunderstandings, that this was somehow a case of similar style and genre and kind of paying homage to Marvin Gaye. But actually, it was, as I say, a classic music copyright infringement case from the standpoint of similar identifying features. And for example, here's one, and this was shown in the lead sheet, so we were allowed, this is actually similar to what was shown from the jury. So I noticed that Marvin Gaye's song had used a particular device called word painting. Now, word painting is using music to symbolize the lyrics you're singing. For example, if a religious song we're singing that about somebody going up high to heaven, the melody may be climbing up and up the pitches to higher and higher notes as those words are being sung. Or if the lyrics were saying you were going down to Hades, the melody might support that by illustrating musically by going down lower and lower down toward the bass notes. That's what's called word painting, and it is a device that composers have been using for many centuries. It's very unusual for it to be in the popular arena at all. And what I did notice is that both Marvin Gaye and Pharrell Williams did word painting with almost the same notes, and they used it in the same function. So this was one of those red flags that went off when I was analyzing it. So Marvin Gaye had 3 sets of words, and he only used them in one place. And his sets were move it up, turn it round, ooh, shake it down. And when he used those words, mostly the same pitches, the same notes were approached, or at least the same direction. So when he sang shake it down, his voice went down lower in pitch. And so did the equivalent in Pharrell Williams' song. Now, in Pharrell Williams' song, there were also 3 sets of lyrics in slightly different order, but they did the same thing melodically in his word painting when he used them. So Pharrell Williams' song was shake around, get down, get up. And those notes with words like up and down were the same. So that I called it the target notes. And what was similar about them too was their function. Each of them were in a bridge section next to a one-time occurring special section of each song. So they became what I called the bookends of each song, and they were only used once in each song. Next slide. And I was able to play this in court, by the way, with a mashup going back and forth between Marvin Gaye and Robin Thicke's singing of Blurred Lines, because it was illustrated in the lead sheet. We were allowed to use this. Next slide. So as I told you, this word painting location was exactly similar to the next similar section that I found the 2 songs, and that was this. In Blurred Lines, that word painting occurred right after a key section, which I'll call the deviation section, which was a rap section. In Got to Give It Up, the word painting was right before a deviation section that occurred only once in Marvin Gaye's song, which I'm going to call the parlando section. Now, what was a deviation here? What a deviation was that up until the parlando section in Marvin Gaye's song, he had a very wide vocal range, and he sang melodies that went from low to high, a good 2 octaves in range, usually, with high falsetto notes and lower chest, what you call chest notes, etc. And that's the way he wrote music for his voice, and he was the main singer in his song. And it was very melodious, and he sang about particular, parts of the storyline of his song in Got to Give It Up. And then he stopped dead in his tracks in a way and had this different section in which the notes were at most 3 notes apart, not 14 or 16 notes, 3 notes or less. They were in a monotone in which he more or less chanted as almost half spoken, half sung. And in music, that's called parlando, meaning it's speech type of singing. This stopped at one particular, his main song stopped at one place, and then came the word painting, and then came the parlando. And 15 bars later, Marvin Gaye returned to his earlier version of the song, so to speak, and continued to the end. So it never came back. So it was 15 bars of deviation preceded by the word painting. And Blurred Lines did the same thing structurally, in that there was a third artist named T.I. who was brought in to do a spoken rhythmic rap for one section of Blurred Lines. Before and after that was the main song sung by Robin Thicke in his melodious, more or less tenor voice. And then it stopped dead for this rap for 15 bars, and then was followed by word painting, and then it went back to the main song. What was interesting is that when we were permitted earlier to have the recordings before that was barred, they were down to the exact same millisecond that the parlando and the rap began and ended. And in the lead sheet that we are later restricted to with Marvin Gaye, they were shown on the lead sheet in exactly the same measures, or bars as it's called, as the rap. So it's not that the rap and the parlando had the same words, but their location was such that it suggested that the template of Marvin Gaye's song was basically what was used to create Blurred Lines. So this was an important similarity or discovery, which I did describe to the jury in greater detail. Next slide. So we're going to move on to a few cases that have had responses to the initial decision of the Marvin Gaye case. And I was not an expert in the cases you're about to hear about, although I have done musical analyses of them and do discuss them in the course I teach at UCLA. So I'll just play each of them and give you a few pointers on it if you like. So first and you know that this Led Zeppelin case, I'm sure you may be aware, has been very active for many, many years in the courts. And the judge, after the Marvin Gaye case ended in the district court, in the first trial, the judge in the Led Zeppelin case did refer to the whole lead sheet issue in terms of barring a recording for a while, and other elements that came out of the Marvin Gaye case. So it definitely had an influence on future decisions in that way. So I'm going to play for you a moment from the original recording, the accusing party, and then Led Zeppelin. You can hear the relationship a little bit. So you might hear some of the relationships between them. As a musicologist, I would focus on the guitars in the introductions of both. They're both playing a form that's called an arpeggio, which means basically one note at a time of 3 to 4 note chords, or they could be longer chords. But the idea is plucking the individual notes of a chord that otherwise might be strummed on a guitar or played all the notes together on a piano, say in your left hand while you're playing the melody in your right hand, for example. So they have a similar guitar arpeggio that they share. They also have a similar, what you call descending bass line, meaning the bass line moves down to lower and lower notes. And those are parallel between them. And I think probably what initiated the accusation. And there were, this has gone on for years and years in the courts. But basically, I'd say that the opposing side, meaning the defendants, Led Zeppelin's team, were very successful in finding prior art from the literature that pre-existed and preceded the writing of Taurus, and contained similar arpeggios, some of which were closer, in fact, to Stairway to Heaven than Taurus was, because they weren't identical, and similarly with the other elements that they had in common. So I think the other side was quite successful, the the defendants, in presenting a very large body of musical work that showed that really the elements at issue were not original to either song. So that's my sort of synopsis of that case. And then next slide,
Could I
please.
just follow up on that point a little bit, Judith? When you say not original to either song, we talk in copyright law about things like sans affaire, and usually that comes up in literary type situations. So, for example, two works are about the French Revolution, so they both have a guillotine. So you can't point to the fact that they both are similar in having a guillotine to say one copied from the other. Is that what you have in mind here as well? Would the arpeggio be something that's sort of to use language not from literary enough, but from the computer copyright area, sort of a standard feature or a standard?
Yeah, I would call it a musical building block.
Okay.
And they're not identical anyway. So, they had kind of two challenges. One was that they weren't identical, and the other one was that they didn't originate with the writers of Taurus.
Yeah, and more importantly, it didn't originate with Led Zeppelin either necessarily. It was just something that, as you say, is a building block, or like trying to get a copyright in the alphabet, or
right.
A certain type of sentence structure or something like that. Yeah.
Right. It's more, in a way, it's sort of like sharing a stylistic component instead of what I would call, a straightforward compositional, element, more like the Marvin Gaye case was.
Yeah. Okay, thank you.
Thank you. Okay, next slide. So we have another case that's wound its way through the courts and through many areas of the news and all, which is Marcus Gray and Katy Perry. So I'll start by playing their music, and then we'll talk about ways in which the Blurred Lines case was referenced here too.
You know what it is? I love it. Yeah, y'all know what it is. Katy Perry, Juicy J. Let's rage.
I knew you were gonna come to me. And here you are, but you better choose carefully. 'Cause I'm capable of anything, and
So, so here's a case again. I wasn't the musicologist in this case, but what you had here was a similar series of notes that are used over and over again in Marcus Gray. That's called an ostinato, an Italian term for repeated, let's call it a repeated musical phrase. That in essence was the foundation of his song over which he was rapping, for example. And Katy Perry used, I think it was considered identical, very, very close, certainly. I haven't analyzed it in full, but very, very close. So in a musical sense, it was a legitimate claim, that these were similar. They were substantially similar. And in fact, they had certain recording features that were similar in terms of their electronic, what you call timbre, meaning what kind of instrument they were played on. But that's not as important in terms of the underlying compositional similarity, but their pitches, their rhythms, and any other elements that they had in common, such as harmony or lyrics. In this case, we weren't talking about lyrics. Those would be what would be considered for the underlying musical copyright protection. And I'd say they had a very strong case in the complaint in that way, musically speaking. But the other side was successful, I believe, on appeal. I think at first was not successful, but did, I think, prevail in the appeal. And part of it, I noticed in the judge's opinion, had to do with the similarity of, so to speak, building block features, meaning that, yes, they had a collection of similar features, but these features by the judge, at least, weren't considered individually copyright protectable. I'm not sure musically I agree with that, but again, I wasn't involved in the case. But I just say that here you have something that's very close to identical, used repeatedly as what you would consider the foundation of the first song. I mean, the whole song is built on this. And the second song appears to have either copied it or in some way written something very, very close, depending on access considerations. But apparently it wasn't considered original enough to withstand the test of originality or the savoir-faire approach that we spoke about in the prior case.
Yeah, let me ask you, I mean, how do you think about building blocks? How do musicologists think about that? I sense from your comments that you had a little disagreement or possible disagreement with the judge's analysis. But how would you, is there a set of things that you'd learn in Musicology 101 that would be the building blocks and then everything else is the original? I mean, could you give us guidance on this? Because I know I've been an expert or worked with experts in architecture cases, and there's always this question about what standard features are in architectural works. But I think there's a little bit more history. There's a little bit more sense of, buttresses and columns and other types of features. How does that work in musicology?
That's a great question. Well, the reason why I differ a little bit with at least some of the opinions, and I'm not a lawyer, so I don't mean to go beyond my own expertise at all, but is that the sort of collection of features that a judge has cited in a lot of these cases in which they've sort of thrown out the idea of collective similarities. Some of the features are not relevant as what I considered part of the character of the composition, and I'll describe which features are, but they put them all together. So they'll talk about things like remember I said that the timbre of the instrument, the electronic, was very similar, but that is not what I would consider a feature of the composition. That's a choice of arrangement. Say you could take the same notes that Marcus Gray, his ostinato, was using and play it in a different key or on a different instrument entirely, or have other features that didn't make it sound like the same instrument as heard in Katy Perry. But if it has the same notes, that the underlying notes are part of what I would consider compositional features that should be protected. So there was a blend in the judge's decision about things that don't matter for the composition, such as tempo, and I don't remember the exact, but the collection was the net was cast wider than is accurate musically. And there needs to be a distinction, I think, if that's going to be argued against. But
right, and I think that might lead us. We have about 10 minutes left, Judith.
Right.
So I know we wanna, but I think your comment about choices, what choices the composer has was interesting. That's what I gathered from one of the points you made in your comment, and that takes us nicely to your material that you have in the slides about artificial intelligence, I think.
all right, so I think what we'll do is we'll move to technologies. So we're going to actually move to slide 15, Justin.
Well, and can we make your entire set of slides available if possible, or if not, that's
yes,
okay.
these slides would be available.
Okay, all right.
I mean,
Let's-
we're going through them sort of quickly, just
Yeah,
before I turn, so you can, thank you. So before I start in this part, though, I'll just say that the intervening slides that we just skipped are slides about sort of where does the musicologist come in. I feel like I've more or less illustrated, but the musicologist's role, in my opinion, and my experience, is as an educator to translate, the complicated and technical musical elements and analysis to a non-musician, and also to integrate that with the legal concept of protecting intellectual property. So that's why I saw myself on my first slide as kind of at that intersection of, well, it's the intersection of music and law, but it's also technology, because technology itself creates a lot of changes in how music's created and used and copied. So the first step is borrowing. Next slide, please. So as I mentioned in earlier, I'm sorry, go back to the earlier slide. That was a mistake on my part. Thank you. So as I mentioned in my earlier slides, in which I showed you more or less the progression of the partnership between music and machines, when music was digitized, in other words, when we went from basically analog recordings to what became compact discs, and meaning music had become digitized, it changed the landscape of how music was created, how it was copied, how it was protected, and how it was basically taken. So that you started to hear music, particularly within the hip hop and other genres like that, in which you heard a sample from a prior recording. And before the law caught up with the behavior, was a long time, many years. It was close to a decade before the law did anything about it. So that you had a lot of music that wasn't selling in large quantities. So there was very little enforcement against this, in which you'd have a hip hop recording in which the so-called bed, that basic repeated section that we hear, sort of like the Marcus Gray in the Katy Perry case, that's repeated over and over again, might be, say, a drum track with some kind of electronic playing, and over that you're rapping rhythmically, either singing or rapping over it, but that's your musical background. And that often came from someplace else, and it became more and more sophisticated with the ability to sample other recordings. For example, there are famous recordings in which Ray Charles, who had a famous scream, was taken and placed in another recording. Often without authorization by Ray Charles or his estate, for example. So that there was a kind of Wild West that occurred, because suddenly one could take what is in essence the master recording, and just take something off that recording that they might like, or that they might feel they want to comment on, or they'd rather use it from a recording than pay a studio musician to play it. There are many different reasons, and this created a kind of Wild West of music until there was a big lawsuit about it, which was called the Grand Upright case, in which Biz Markie was basically called a thief by a federal judge, Judge Duffy in the Southern District, who at the top of his opinion said, "Thou shalt not steal." And he referred it to the prosecutor, and all of a sudden overnight, a whole licensing mechanism and businesses that did nothing but give permission and make deals about using samples came into being. But that was also because rap music and the whole hip hop genre had grown to the point where it was one of the biggest selling styles in the recording industry. And they had to do something about this, because this was built completely on third-party materials that were being used without permission initially. And that's where technology took us. Next slide, please. And we're still there, by the way. Sampling is very, very common, very sophisticated, and very easy for even new artists to accomplish with very little need for even a professional recording studio when they're getting their start. And what happens? Well, one of the things that happens and lead to disputes are the way in which music is written upon commission. By that I mean that an artist is asked, say a composer is asked to write a film score, and they want it to sound a lot like some other film score the director does. Maybe has a favorite film score, like the score, by John Williams for Superman or something. But, John Williams or composers of that stature are very costly. And say if it's a small indie film or something, that's not possible. So what will they do if they want the composer to get as close as possible? Well, they'll send a copy of the recording of what it is they want the composer to imitate. And the level of imitation sometimes gets way too close. We're often called in. That's the role of musicologist before any disputes occur, before releases exist. We will be shown the original reference track, which is called a temp track, usually when it's linked up to visuals, synchronized with visual, and then the newly created but similar track, and give an opinion as to whether or not they are very close and are substantially similar and likely to generate a legal risk. So next slide. So this is, as I say, in the industry, this is called a temp track, which is basically using as a temporary placeholder the original one that you really wanted but couldn't afford, or you weren't given permission to use if you asked for it. And then that illustrates to the composer who writes something that evokes it. But how close the composer gets and how far away, and if it's acceptable by the commissioning body, whether it's a director, a film studio, or an ad agency, that's really that gray area that can lead to a lot of legal disputes, because that's also evidence eventually if a dispute occurs. Next slide, please. So where are we today? Today, we are at such a sophistication level of artificial intelligence that what was originally written kind of as an experiment using artificial intelligence and the understanding and learning of musical patterns enough to write something that sounds like Beethoven or sounds like Bach or sounds like the Beatles, to the point where it's almost indistinguishable even by a professional in the field, because of the sophistication and the neural networks systems that are used to evoke musical works in a specific style. A lot of it's built on voice recognition technology, and now very sophisticated what's called re-records, which is really, instead of copying a recording by lifting it, as we talked about sampling earlier, it's replicating on a synthetic basis, line for line, everything from another recording, and then selling it often artificially. This has been done in the case of the Beatles, for example, which led to a lawsuit with EMI, the owners of the Beatles copyrights. But the parties had actually, offending parties had actually replicated, instrument for instrument, voice for voice, to the level of it was like a digital photocopier in essence. But they hadn't lifted it from the original recording. So again, the copyright law hadn't caught up to the reality of the technology. And that's where we are now, frankly. Next slide. So a musicologist, say what would the role be of a musicologist in an AI created musical atmosphere? Well, the truth is that I've never seen a case yet that, at least where the issue is that it was machine created music. But I think the US Copyright Office has become very clear, I mean, stemming from the monkey case and some others and other art forms, that, non-human created art is not protected. But you have collaborations, for example, and why is it attractive? Because computer created music doesn't have an owner, in the sense that, it doesn't maintain its copyright for something like Life Plus 70, because it doesn't ever die. And also, if it's built on earlier material, like say you fed in all of the music of the Beatles and then told it to write something that was very Beatles-like, and again, the ability to replicate all the metrics of a piece of music down to its really fine points is so advanced now, that it's very hard to detect what's machine created and what's human created, or if there's a collaboration. So then there are elements about split royalties, and I'll say, if you have, as has been done on Sony, a recording in which the recording artist is singing and has written the lyrics and the vocal lines of a group of songs on an album, but the music that's supporting that, the accompaniment, is all AI created and intertwined. So the co-author in essence is machine. And what happens with royalty splits and other kinds of permissions that are granted in the future, if those recordings are sought, permission is sought to use those recordings in new ways or re-records. So now I think that's our last slide. This is what I wanted to say in closing, was that the analysis won't change. A musicologist's analysis of this wouldn't change, because I really analyze the musical properties involved, the pitches, the rhythms, the harmonies, and musical structure, and those that I've illustrated in some of the other cases. But how they became a piece of music and who created them is actually not as much my concern yet. It may become, the musicology may have to embrace some of these new developments, but so far I would still analyze it as a complete piece of music with its various properties. So thank you so much for inviting me, Professor. And
thank you, Professor. This was really wonderful. There's so much to touch upon. Let me just end with two quick questions, if you don't mind. One is, in your consultations, whether it's at trial or in a situation, before a musical composition is released by a studio, you mentioned you do some consultation there as well. As far as, has the issue of fair use ever come up, or
yes.
How has it come up in your work as a musicologist?
Because I'm often asked to dissect the music into what elements are protected and what aren't. And if it's a commonplace element, it could be as commonplace as structural. It could be, that they are asking me, well, this song has an alternating chorus and verse, or a call and response where the main singer sings something and a chorus responds with some kind of declaration. And they go back and forth in kind of a dialogue. And I might be asked, Does that mean we've copied this other song that does that with Aretha Franklin? And I say,
see.
I'll look at it and look at the pitches that Aretha Franklin is singing and the lyrics and the harmonies that, multiple pitches at once create. And I'll determine if they've actually copied the composition or simply the style. So the style and the more conceptual parts would be in this realm of fair use, in my opinion.
Yeah, interesting. Yeah, it's a big area to be developed, and I think will come up, especially in the sampling area. I'm not sure where it'll go, but some people are saying with the recent Google case, fair use in music might be something that would come up. I'll end with kind of a philosophical question. Do you think a AI system can ever produce an operatic a performance as great as Pavarotti or play the flute as well as Galway? I mean, the performance side of AI seems like it'll never match up with the human. Or do you think I'm not giving AI enough credit, or am I giving humans too much credit in music?
That's a wonderful question. I've never been asked that before. I think it's easier to go beyond human capacity, which is already being done with auto-tune and a lot of other electronic assisted devices. I mean, that where they expand the range or they expand the, they sharpen or flatten something if it's wrongly sung, because humans make mistakes. Or one day they don't have as much breath support in their singing or their flute playing. So I'd say that it could actually go beyond that. I think most electronic music can go beyond the human, but the compositional part I find more troubling.
Oh, that's interesting. Kind of the opposite of what I was thinking. I mean, there's something about watching someone like James Galway play the flute that I can't imagine going and watching a robot play the flute.
I agree. Then you're just listening to a recording in essence.
Yeah,
It's like watching an Olympic gymnast rather than
Versus-
sort of a
yeah.
replication of that by robot.
Well,
Because
thank
that
you.
human uncertainty
Yeah,
is removed. Yeah.
yeah, it's interesting. And then there's just the way in which human breathe, I mean, just that human element of breathing and so forth. Well, this has been wonderful. Thank you for taking your time, and all the best with your consultation work and your teaching. Looking forward to going back to face and hybrid at our respective universities. And I hope we can have you out to Syracuse sometime, and we can continue our discussions with a bigger group and face to face. So thank you so much.
Thank you so much for inviting me, and I'd love to come when it's okay to travel.
Thank you once again.